Go ahead. I'm sorry. Are they taking him to another floor? I wonder. Because we need to probably tell him don't do that. No. We'll be under the floor. I'll run around making videos. He's probably deep though. Ready? Okay. And Mr. Ambrose, back on record, I had an opportunity to review the case that you provided.
Okay, thank you.
Go ahead. You may continue.
All right. Yeah, it doesn't surprise me that Joseph Gant saw that rotary sign in the garage, because he was in the garage. It's just my client wasn't there at that time. And, you know, this is his testimony. I'm going to bring up this from April 21st, where
page 44.
And Bob was there as well from 6 o'clock to 7:30, and he says that's correct. That's
Okay.
Joseph Gentz's testimony.
Okay.
And then the trial testimony, indisputably, we have, just as a comparison, this is Michael Carmody. That he received a phone call at 6:40 that evening, and from my client, and that he arrived there just a couple minutes after 7 o'clock. So that's Michael Carmody. They meet at 7 o'clock at the Hard Luck Lounge. My client was there. So, you know, and that's Michael Carmody's testimony. There are others, many others, who had seen my client there at 7 o'clock. You know, actually, well before that, 6:30, he arrived there up until 8 o'clock in the evening. So, you know, it's just not Michael Carmody, but Michael Carmody is, I mean, that is compelling evidence that he's there at 7 o'clock. Joseph Gentz says my client was there from 6 o'clock to 7:30. It's just, there's diametrically opposed. So,
By about 30 minutes.
yeah. Well,
Be quiet.
I'm sorry, excuse me.
I mean, he can't be at the Hard Luck Lounge at 7 o'clock until 8 o'clock and be at 552 Middlesex at 7:30.
But he could be there from 6 to 7, couldn't he?
Not based upon the other testimony in the case, as well as there's phone records showing phone call that he made from the Hard Luck Lounge, you know, hitting off the tower near the Hard Luck Lounge.
At what time?
I believe one was 6:28. So there's so many areas that I want to get into, and you know, I'll renew my request to get into these areas. I wanted to cross-examine Joseph Ganson from his initial statements that he made to the police, you know, back in 2012 on January 31st and February 1st. And, you know, if I was allowed to do that, and I have the video clips, I can just show the court.
I don't even remember me telling you limiting your examination of Mr. Gantz. I never said you were limited. There was a request by the prosecution to limit it. However, there was nothing precluding you from doing it. You didn't do it. You had the opportunity.
I wanted to get into all these.
But you didn't get into it.
I think the court made the determination that I wasn't allowed to.
I said anything that occurred before the murder, such as when there was an allegation with the neighbors that Mr. Gantz had cornered up some little kid or something like that. I didn't preclude you from doing that. I never would have precluded you from impeaching his testimony.
Because it...
Take a look at whatever Mr. Bashara told you to look at.
Because my record...
I don't need you to talk. You have a lawyer.
I'm sorry.
Because if that's the case, Your Honor, I want...
Just read what it says.
All right.
They set the parameters here, and then she changes.
That the court was going to limit itself to the information that was contained in the affidavit. Page 20. But I mean, once again, I wanted to get into all this.
And very good, and the court even allowed questioning of you that you asked Mr. Gantz, isn't it true that you stated in your affidavit that it occurred at 7 o'clock? He said, no, that has something to do with something else. Didn't you tell the investigators, the police, that when you were being interviewed by Grosse Pointe, he said that has something to do with something else? I allowed you to ask that question. But go ahead.
So,
just go ahead.
Okay, I will, because, you know, these are the things, the items that I wanted to get into. Everything from...
To sit down and talk.
Your Honor, you know what? If you don't cut that off, you got the problem. Don't present the evidence before me that wasn't admitted. We're not going to do that today. All right? And don't assault me. All right, let's just move on. See, you know, see, what's so amazing to me, Mr. Ambrose, is that, you know, you have filed extensive briefs in this matter. You didn't interview Joe Gantz after he does the affidavit. Then when he gets up here and says that your client, there were 3 people in a garage, me, Bob, Jane, and God, and also God. Now you want to make him out to be this villain, but before, in your brief, you said, hey, this is the key evidence. This is who is going to set my client free. This is newly discovered evidence. Now, based on when he decides to recant, after you didn't interview him to even know what he was going to say, now, I want to bring other things in to impeach his credibility, but you were the one, not only in your quest for new trial, that said you wanted to cross-examine him because the prosecution had backdoored his statements into evidence. You also filed a supplemental motion based on newly discovered evidence, based on his affidavit that you didn't interview him, and now, we want to crucify, we want to say he can't be believed. You can't have it both ways.
I don't know how much more I can do with what...
You could have talked to him.
If
You
I-
could have found out what he was going to say to make sure that what he said was consistent with that affidavit and not trusted a jailhouse lawyer. That's what you could have done.
When he goes in front of a...
I don't care if he is in front of a notary. He could be in front of a judge. I have people lying to me all the time. Lawyers, witnesses. The point was you could have interviewed him. Say, is this what you're saying? Is this true? And now what you want to do is you want to retreat from what has been placed on this record because you didn't talk to him. But go ahead. I'm listening. Let's go to something else.
All right, wow.
But you made your record. Go ahead, you can finish up. I'm going to give you about 15 more minutes and then that's it. And I'm going to stop interrupting you. Go ahead. Okay, the other things. Then you start talking about failing to present medical records of her condition, failure to object to the BDSM lifestyle of the defendant, the other areas that you want to talk about. You said there were 5, and that's what's included in your motion.
Well, yeah, I mean, those are important aspects of the case to show that my client... What I want... Go ahead.
As well as your client wanting to present Chief Hiller
Right.
to show the grudge. But go ahead, keep going.
Right, and you know, why don't we stay on that? As to the grudge issue, you know, that was denied by Chief Hiller, you know, that there was no grudge. He testified as to that. But then...
Keep your voice up.
Joseph Gentz tells the court, you know, in his testimony, that they wanted my client over the quote-unquote alleged sexual abuse that occurred, you know, back in the 90s, and that they missed their chance at that point. I mean, he does testify as to that. So it verifies that issue about this so-called grudge. And how else would Joseph Gentz know about this if he wasn't told by either Chief Hiller or somebody within the department? He has no way of knowing it, but it's verified through his testimony. You know, can I...
Go ahead.
One of the things that Joseph Gentz says in his testimony is that the police came to see him on the 28th. I don't know if the court can allow me to present the DNA swab that they took, and it's dated January 30th. That was at the time that they first saw Joseph Gentz. Not only did they see him, they released him at that point, knowing that he had committed murder. And then when he walks into the police department a day later, also tells the whole story, stayed there for 2 days, and they release him at that point. They don't re-arrest him for another month. So what I'm getting at is, yeah, my client, or Joseph Gentz, was released twice after they had evidence of him committing this murder.
Okay. But they do charge him. They don't just say, just go ahead and go. Thank you.
And
so what's the relevance of that? Yes, they do let him go. But then they ultimately charge him. How does that prejudice your client? Mr. Bashara.
I'm sorry, Your Honor. I'm sorry. I know this forward and backwards,
and we know you know it
and
forward
this
and
is my
backwards.
life we're talking about here.
Okay.
All right? And I'm, you know, and there is case law on a defendant also assisting in his defense. And I don't have the cases with me, but, you know,
You have a right to assist in your defense, but you do not have a right to be disruptive. And
I don't mean to be disruptive. I mean to aid.
Okay, excuse me, Miss Madam Stenographer, can I take down 3 voices at one time?
I'm sorry.
Okay, that's what I'm saying. I don't have a problem. You can write down whatever you need to give it to your counsel. I don't have a problem. It's taken a year for me to do this motion, so it's not like I'm in a rush. I want to make sure that justice is served too, sir.
Absolutely.
Mr. Ambrose, go ahead. Mr. Ambrose, what are you doing?
I'm trying to find this. It was on January 30th, that this DNA swab of Joseph Jensen. So, you know, at that point, they had evidence of his, at that point he tells the police that he committed this offense.
Okay.
And that's, you know...
So does that go to the grudge?
Well, it goes to... He walks into the police department at the very get-go wanting a deal. I mean, he goes in there with statements...
What's that got to do with your client?
Because the affidavit shows, or that he presented, that he was going to get a certain amount of time for his statements against Robert Bashara.
But just a minute ago, you said the police let him go and didn't charge him. So based on what you're saying, that somehow they're giving Mr. Gintz special treatment, but then they ultimately charge him. So, and he wants a deal. What does that have to do with your client? I'm not following along.
Because they wanted...
They being, sir?
The police wanted Bob Bashara.
Okay.
And if I misinterpreted the court's ruling about me getting into all these other subjects,
that's fine. Just keep going.
I apologize, because
That's
I can certainly show the court with these videos.
Not now. Go ahead. The other points you want to make?
Yeah. I apologize.
That's okay.
I'm going to play something for the court that had been played during Joseph Gentz's testimony.
Go ahead.
For a collect call, press 0. Please at the beep, repeat the phrase with
Well, I haven't heard it.
You were playing.
Let me just state in the court what it is.
Go ahead.
I'd rather have it from his own.
All right, Will. Go ahead.
But anyways, you know, he says in the interview, is asked him, did Bob hire you to kill Jane? And he says no.
Okay.
All right. So there's, you know, at the very least, you have that. He says specifically, this is a, you know, independent interview that he's saying these things that are inconsistent with his testimony that he had before the court. He also says, you know, Gentz admits to the murder, and when asked, you know, was Bob there? When he had the chance, he flat out and says, I'm not going to say that. Did Bob Bashara have anything to do with the murder? Once again, he said, I'm not going to say that. Bob getting a new trial. He said it'd be great. I mean, no, that's his statement. You're right. Joseph Gentz is a loose cannon. Whether or not I went and met with him, I don't know what more I could have done. If he says to me one story in an interview with him and is consistent with the affidavit, and then once again comes into trial, you know, once again comes into court and testifies differently, you know, I'm still at a loss. So to me, having that affidavit was such a very important aspect. To me, it was a game changer. I think based upon that affidavit alone, that sworn statement that he provides to the court is enough to show that if this case was retried, that a different result could have occurred. Because now we have it. He can't get away from it. He can say, I didn't read it, but all that is impeachable information. He signed it. You know, his explanation.
But he testified contrary to it under oath again.
But
okay.
You know, and you're the judge of credibility, you know.
That's right.
But his explanation about it, that he didn't know what was in there, he doesn't know why he signed it, he doesn't, you know, and going in front of a notary just 2 minutes prior to, that's not how it works.
I understand, and I appreciate that what you're saying, that his statement was made before a notary. But the fact of the matter is, he came in court under oath and made a complete contrary testimony. Completely. He put your client in that garage.
And the times don't match.
Okay.
You know, and they don't.
Okay.
I don't know what more I can say.
And I think that you said enough. Is there anything else you'd like to deal with before I let you sit down?
I think I made my objections.
And you did a phenomenal job. Thank you so much. Response.
Yeah, it's been a long journey. I mean, it's been 10 months since we started this thing. And so it's been kind of difficult to not lose sight as to the reason why we're actually here. There's been a lot of finger pointing throughout this whole thing, whether it's Judge Kenny's fault because his investigators weren't paid enough, or if it's Lisa Lindsay's fault because she was on a crusade against Mr. Bashara, or Chief Hiller's fault because he had a grudge against them, or it's, you know, we even heard it was Jane Bashara's fault because he's a hot-blooded 40-plus-old male that, you know, she didn't have this condition. He wouldn't have sought outside the home some type of sensual relationship with someone else. Everyone's to blame. There's finger pointing all over the place, except for Mr. Bashara. He refuses to take blame. And that's why the reason we're here is because now he's blaming Mr. McCarthy, Ms. Diallo. That's the reason we're here. And the reason why he's blaming them for it is because they didn't abandon their training, their experience in doing their job for this long of being licensed attorneys, because they didn't listen to him. He knew exactly what should have done, what questions to be asked, what evidence to produce, and because they disagreed with him, they were ineffective and they denied him his constitutional right. That's what his claim is. Now, this court has granted this hearing. And the reason why the court granted this hearing was to allow the defense to present the evidence that they would need to show you, to prove to you that it's a reasonable probability that had they produced this evidence, it would change the outcome of the trial. That's what they were to do. And did they do that? No. There was very little new evidence that actually came out during this hearing. Despite as many witnesses were placed on the stand, the hours of testimony that we had, very little actually came out. And even now at the end, the argument that's being made is, well, if J.J. McKee was here, which they never produced J.J. McKee. They never produced anything that what J.J. McKee would have said. But if he was here, he could have been the difference. If we had the clothes, it could have been a difference. It could have been this, it could have been that, if this, but that. That's not sufficient. The burden is to prove that there was an unreasonable error made and that reasonably probably changed the outcome of this trial. That's the defendant's burden. He had to produce evidence. And what evidence did he produce to sustain any of that? None. At the very beginning, people produced a written response. I'm going to rely upon that unless the court wants to ask any further questions, but I did want to touch upon certain things.
Take your time.
The first thing is Joe Bruce, the investigators. They weren't paid enough. They weren't able to go out and find things. And I just want to go back to my question to Mr. Bruce was, okay, if you were given all the money that you wanted to go out and do the investigating that you wanted, if you had all the time, all the money, what would have you done that you hadn't done? His response was, I would have gone out and found J.J. McKee. I would have solved this crime. It would have been J.J. McKee and Joe Gentz, not Mr. Bashara. Well, again, we've heard no evidence, even though it's the defense burden to prove this evidence, to present this evidence. But no one asked Mr. Bruce to do that. Not Mr. McCarthy, not Mr. Diallo. His job was not to go and solve this crime. His job was to assist them, do the investigation, to find these things. And when we asked Mr. McCarthy, we asked Mr. Diallo, was there anything that Mr. Bruce, Mr. Glaspie didn't do that you wanted them to do? No. They did everything we asked them to do. The other point is Joe Gentz. And to say that it didn't turn out as the defense expected when Joe Gentz took the stand, it's unbelievable how different it was. The point I want to make on that is, on the affidavit, he denied it, called it garbage. Said, I never read it. The court, very shrewdly, I thought, give you compliments for this, had Mr. Gentz try to read this into the record. He couldn't do it. He didn't know what these words were. Couldn't pronounce these words. Couldn't spell the words. That just proves that he had nothing to do with this affidavit, besides signing it, to which he said, I didn't even read it before I signed it. The statements that Mr. Ambrose wanted to play for the court, as far as the statements to the reporters. When Mr. Gentz took the stand, took an oath, under pains of perjury, to tell the truth, what did he say? He said, Mr.
Oh, excuse me, I got to interrupt you.
Sorry.
As well as the court had advised him that the people could withdraw his plea to second-degree murder if he testified. He chose to take the stand.
Exactly.
Go ahead.
And what did he say? That Mr. Bashara was there in the garage. He was right there. He ordered me to do it. He said, take her out. That's what Mr. Gentz said, under oath in this courtroom. Not to some reporter on a phone call. Not in some affidavit that he had nothing to do, that he says he didn't even read. In this court, under oath, Mr. Getz, Bob Bashara told me to kill her. He was there when I did it. He directed me what to do, so I did. That's the testimony. And that is entirely consistent with all the evidence that was presented. Because it wasn't just Joe Getz. You had a multitude of other things, including Mr. Bashara telling his cocaine dealer, I killed my wife. Telling his bunkmates in the prison, I had my wife killed. There was an abundance of other evidence that was presented at trial besides Joe Getz. Bottom line, Your Honor, the defense had a burden, and they just failed to make it. Thank you.
Mr. Anderson.
Part of the problem with the investigation was
I'm going to give you 10 minutes. Go ahead.
Was that they were not given the contact information that they needed. That goes to my first issue. I'm not here to say that the attorneys for Mr. Bashara didn't do as well of a job as they could have with the time that they had. There just wasn't enough time, and there wasn't enough information provided to the defense team to do an adequate job. Plain and simple. With 300 witnesses and they're only able to interview 11 of those, that is inappropriate and should not be a way to run a defense in any type of case. 300 witnesses and they only are able to interview 11 of them because the contact information was not provided where they could just go out and meet with these people. J.J. McKee is an important aspect of the case. No contact information from him. What's so surprising is that the police had information that J.J. McKee and Joseph Gens are at my dad's bar on that evening after the murder, wringing their hands, pacing, a lot of hand, I think the quote was a lot of hand wringing. And they don't require J.J. McKee to do an investigative subpoena. They don't require him. They just say that he is not cooperative, and they end it there. Well, not only don't they get any more information from J.J. McKee in terms of investigative subpoena, they don't get his phone records. They don't do anything like that. Plus, they have information that he scrapped the car the very next day. That is a compelling reason why somebody would want to talk to J.J. McKee. And without having anything more, they just dropped it. And Joseph Bruce, our investigator, testifies that he was able to review the interview with Joseph Gens. And I want to get into just briefly. I'm reiterating, but Joseph Gens says that this, without a doubt, is a semi-automatic weapon that was used. Well, what's being paraded in front of the jury was an antique revolver.
And when asked about the gun, he says, I don't know what kind of gun it was. All I know was I was afraid, and he put a gun to my head. The fact that if he had said earlier, he said he didn't remember saying that. But the fact that he said a gun was placed to his head because he didn't know if it was an automatic or he had said it was an automatic and it was a revolver, he said there was a gun placed to his head and that your client directed him to kill his wife.
And I wanted to refresh his recollection or impeach him, and I was not allowed to.
Okay.
And it was with these video clips.
And you asked him whether they were a video clip or not. You could have asked him, and you did. You asked him, didn't you say that it was a semi-automatic? He said, I don't remember.
Right.
All I know, he put a gun to my head. So the fact that he had made it said at the Grosse Pointe police station that it was a semi-automatic or automatic, whatever, he still consistently said that your client put a handgun to his head and told him to, let me get the words right, shut her up, do it now. Go ahead.
But at one point, 4 days after this murder that Joseph Jens commits. He specifically tells the police what type of gun it is.
And his statement to the police, which he indicated in court that he didn't recall, was not under oath. But under oath, he indicated that your client put the gun to his head and said, "Shut her up, do it now."
All right. But at trial, if I may, or whoever is able to impeach his testimony, without a doubt, he's going to say that it was a quote-unquote automatic. Well, what's the gun that was found and paraded in front of the jury was a revolver. So that gets thrown out because that has no relevance in the case because it wasn't a revolver that was used. Yeah. Your Honor, I'm gonna close my remarks here just with a couple of statements as to the law. I provided the court with a copy of that decision. It's a Sixth Circuit federal case. The case arises from the state of Michigan, so it has precedential value. Under MCL 770.1, the court can grant a new trial for any cause by law, which a new trial can be granted, or when it appears to the court that justice has not been done. I can reiterate and pound the table as hard as I want that we have that. We have my client not being at the location of when this murder occurred. That's not disputed. Nobody can get away from that. MCL 769.26 is another provision which the court can rely on when granting a new trial. There's enough evidence that the court can find to grant my client a new trial. And I'd ask the court to do that. Justice has not been done in this case. This theory of the prosecution never made sense. And so I'd ask the court to grant my client a new trial.
Very good. The court is going to render, thank you both. And before I leave, I want to say this. This has been a very, very long process. Both attorneys have done a wonderful job. Absolutely wonderful. I know more now about the basis of granting a new trial and newly discovered evidence than I have known in my 19 years. And I thank both of you for doing it. You did a superb job with supplying the court with case law. It was absolutely unequivocally appreciated. However, the court will render a decision. I'll be back out at 12:15, and I'll be ready to render my decision, and we will go from there. Court's in recess. 12:15. Hey, is Josh back here?